Good afternoon. Mr. Gammy, I think we're ready to resume.
Thank you, my lord. Good afternoon, my lords, my ladies. I just wanted at least to acknowledge the fact I had not forgotten that I had said there were two key issues. The first was the assumption of responsibility, which I spent most of the time, as I said I would, before the short adjournment. That just leaves me with the second key requirement, which has to be satisfied, the unconscionability issue. The Court of Appeal dealt with this in paragraphs 68 and 69 of their decision, which is on page 161 of the electronic fund law. And essentially, their assessment of the overall justice of the case focused on three matters. The source of the assumption of the common assumption was the revenue, and specifically what the Court of Appeal regarded as a misrepresentation by the revenue, the fact that the revenue were at fault in relation to the misrepresentation, and as the court put it, that the revenue have only themselves to blame for what had happened. In relation to that, I make 3 points. We say that the court's assessment of those matters is flawed, in particular for the reasons I've already given. We say it's unfair to characterise the revenue's letter as including a misrepresentation or suggesting that the revenue have only themselves to blame in this particular case. Secondly, an assessment of unconscionability, we say, is an intensely fact-sensitive exercise to be carried out by the fact-finding tribunal, here the first-tier tribunal. And in the present case, the first-tier tribunal held that it would be unconscionable for Mr. Tinkler to be permitted to resile from the common assumption under which the parties had operated. And the first-tier tribunal's assessment is at paragraphs 151 to 161 of its decision, there in the bundle at page 211. I won't take you through that now, but that's for your note. And thirdly, I say that the authorities are clear, the authorities I've already taken you to in particular, that none of the 3 matters on which the Court of Appeal focused is a bar to estoppel arising or precludes a finding of unconscionability. And I've already shown the court that it doesn't matter that the revenue initiated the assumption that they were at fault in doing so. And even if it were right to say that the revenue were wholly to blame, that would not be a bar to an estoppel arising. We deal with these points in paragraphs 66.1 to 66.3 of our written case on pages 91 to 92 of the bundle. And as a result of those areas, we say the Court of Appeal's assessment of this particular issue was flawed. It failed to appreciate and take proper account of 4 key matters, in particular as set out in our written case at paragraph 68, that BDO's role in the adoption of the mistaken assumption by responding and interacting with the revenue in the way that I've shown you, that BDO knew that the Haybridge Lane address was incorrect, at least from October 2005, and in any event, we're in a position to check whether Mr. Tinkler had in fact received the inquiry letter. The fact that Mr. Tinkler and or his PA in fact knew about the inquiry from at least November 2005, and fourthly, that Mr. Tinkler has suffered no prejudice or detriment whatsoever as a result of the revenue's mistake in sending the inquiry letter to Haybridge Lane. BDO notified the amendment to his return, as we saw, dealt with the inquiry into his return on his behalf and with his knowledge, and it's never been suggested that he would have acted differently had he received the inquiry letter that had been sent to his old address. And the only consequence of the estoppel arising, insofar as Mr. Tinkler is concerned, is that the gilt strip scheme he participated in comes open to scrutiny in the tax tribunal, as was originally envisaged when he appealed against the closure notice. And that we say that's not a prejudice or detriment for these purposes. The party that has suffered detriment in this case is the revenue. And so for all those reasons, we say the Court of Appeal was in error in relation to its consideration of the unconscionability issue. In the present case, Mr. Tinkler is seeking to resolve from a common assumption in circumstances where that assumption was reinforced and perpetuated as a result of the active conduct of his agent, BDO, and was subsequently acted upon by both sides for a number of years. As a consequence of BDO's conduct, the revenue relied on to their detriment on that common assumption, and the procedural defect with the inquiry notice has not been shown to result in any prejudice or determination to Mr. Tinkler, yet by virtue of it he seeks to deny the common assumption so as to avoid the guilt strip scheme in which he participated coming under further scrutiny, and thereby benefit from the losses that he claimed when he amended his return in July 2005. And we say that's a paradigm of unconscionability, and the Court of Appeal was wrong to interfere with the first tier tribunal's correct assessment of that particular aspect of the matter, and therefore to conclude it in favour of the revenue. So in those circumstances and for those reasons, as set out in our written case, the revenue respectfully invite this court to allow the appeal.
Mr. Gammy, thank you very much. Mr. Thomas.
Good afternoon, my lords and my ladies. I should begin by addressing in a little more detail than my learned friend has done the background to the Commissioner's appeal. This case has reached the Supreme Court, not because of anything that Mr. Tinkler did, nor anything by a reason that anything that BDO did. We are here because an officer of the Commissioners, Officer McKay, deliberately and without reference to anyone else decided he would not send a notice of inquiry to Mr. Tinkler at the address to which the Commissioners had been told to send such correspondence, an address which they already held on their system as the right address, but to another address which had once been Mr. Tinkler's address, but which had some time before ceased to do so. And this was something of which the Commissioners should have been aware, and Officer McKay should in particular have been aware. The Station Road address was shown as the address on the relevant self-assessment return. It was also used as the appropriate address for correspondence in the Form 64.8, which appointed BDO as agents to correspond with HMRC and authorised HMRC to correspond with BDO. And one sees that at page 231 of the bundle. And one sees halfway down the page, please give your details here, and he gives his details as W8 Developments Limited Station Road. Haybridge Lane had been struck out from the TBS system, the system that tells the revenue officer where to send correspondence, on the 24th of February 2005. And in consequence of that, the Commissioner subsequently corresponded with Mr. Tinkler using the Station Road address. And one sees that at page 186 of the bundle between paragraphs 22 and 28 of the First Tier Tribunal's decision. I don't need to go through those now, but there's the relevant facts. In addition, the Commissioners had also been notified by Mr. Tinkler's employer in his P60, the employee's end-of-year tax form, of another address, Winder Wath, as his residential address. And one sees that at paragraph 29 on page 187. And yet, despite that, Officer McKay amended the TBS system on the 1st of July 2005 to reinstate Haybridge Lane as the correspondence address. He had no reason to do that, but having done it, he told nobody else. And in particular, he failed to tell Mr. Tinkler or Mr. Tinkler's accountant's BDO. And instead, having inappropriately amended the TBS system without being asked to do so, He then sent a letter purportedly to Mr. Tinkler, that so-called notice of inquiry, but to an address where there was no one to receive it on Mr. Tinkler's behalf. And he followed that up by sending other correspondence to the same address, including a cheque made out to Mr. Tinkler, which he sent in the same month, July 2005, as one sees on page 188 of the bundle, at paragraph 36. On the 14th of July, the Commissioner sent Mr. Tinkler also at the Haybridge Lane address a tax repayment cheque. And that's the cheque which then leads to the correspondence at pages 266 to 270 that Mr. Gammy took you to earlier. And Officer McKay was told that cheque had never been received, and in the course of that correspondence, he was indeed told it was no longer Mr. Tinkler's address. But it appears never to have occurred to him, or possibly it did, we just don't know, but he did nothing about it, that if Mr. Tinkler's cheque had failed to arrive because it wasn't sent to the right address, then it was equally likely that Mr. Tinkler never received the notice of inquiry either, as he'd sent that to the self-same wrong address. And at the same time as he sent that notice of inquiry to the wrong address, he sent a copy of it to Mr. Tinkler's representative's BDO, and that's the letter of the 1st of July, which is at page 254. And what it says in paragraph 1, and you've seen this already, is, I enclose for your information a copy of the Section 9A Taxes Management Act notice, which has today been issued to your client in respect of his return of income for the year ending 5th of April 2004. Now, that was a representation made by Officer McKay on which he expected BDO to rely and on which they did rely. And we say there are, in fact, two elements to that representation. First, by indicating to BDO for their information that he had sent a Section 9A notice to Haybridge Lane, he represented he'd complied with the requirements of the Taxes Management Act, that such a notice be sent either to Mr. Tinkler's business address or to his residential address. And secondly, by sending that letter to that address and representing that he had satisfied Section 9A, he also represented that he could now both prevent Mr. Tinkler doing things such as amending his tax return with immediate effect, and he could also demand information from Mr. Tinkler and his representatives. Now, those are the important representations which Officer McKay made and which the commissioners would invite you to disregard. And we say that in other circumstances, those representations would found an estoppel not against Mr. Tinkler, but against the commissioners. They are representations which, in contract, we say, would found an action for negligent misrepresentation. But what they don't do is to arise in the context of some form of convention between Officer McKay and Mr. Tinkler, or between Officer McKay and BDO. And if one starts by looking very briefly at Lindley Heath, page 718 of the bundle, paragraph 73, what the Court of Appeals says is, estoppel by convention is not founded on a unilateral representation, but rather on mutually manifest conduct by parties on a common but mistaken assumption of law. Its basis is consensual. Just so, and where there is a misrepresentation, an erroneous representation, made by one party to the other on which the other relies, it should likewise follow, we say, that estoppel by convention is excluded because there is no consensus. The representee can reasonably say non est factum. And that, we say, is the position here. The distinction we say between the two kinds of estoppel is that where there is a representation such as that made by Officer McKay, the existence of the incorrect assumption is the responsibility of one party. Whereas in the case of estoppel by convention, both parties will have played a significant part in the adoption of the common consensual assumption. And our case comes to this: one cannot, as the commissioners would do, convert an estoppel by representation, a negligent representation, into an estoppel by convenience, by convention, for the convenience of the representor, because the representee has assumed the validity of what he has been told as he was expected to do. If estoppel is, as appears to be the case these days, an equitable remedy, it would be quite extraordinary if such a series of events were to lead to the duped representee having to accept the validity of the untruths which he has been told. And the party...
At some stage, Mr. Thomas, it would help me if you could explain how that submission works in relation to bench dot.
Yes, of course.
Where, if I recall correctly, the assertion that the proposed steps which the employers were invited to take would stop time running was one that came from the revenue.
Oh, indeed, it does. It does come from the revenue, but then at that stage, the revenue explain exactly what is going on and that time is thereby to be stopped in relation to it. And in one of the three cases, at the very least, the suggestion came from the taxpayer's agent. But in those circumstances, there was an error of law which was adopted by both parties. But in this particular case, the problem we have with the representation which was made here is that it wasn't plain on the face of the record that was something that was going to be important. And one of the things that had been left out of the account was, in fact, that Officer McKay had changed the address to which he sent the notice on the very day or the day before he sent the letter out. If he had actually sent a letter to BDO saying, I have sent this letter today to Mr. Tinkler at an address which I have now used, namely Heybridge Lane, that would have flagged up for the purposes of the consideration by BDO at the very least, whether or not there was an issue which needed to be looked at there. But what he did was to keep silent about that and make a representation which on the face of it was to send the letter to an address which was a correct address. And I will come back to this. There was no evidence, and the evidence which there is tends in the opposite direction. There was no finding to this extent that BDO ever knew what the right address for Mr. Tinkler was. And they certainly didn't know that, we say, on the 6th of July when they received that letter or replied to it. And we say the parallels with contractual misrepresentation are helpful, and it would historically have been open to a contractual representee to seek rescission of the contract. And we say it's likewise open to Mr. Tinkler to demand that any convention which might otherwise be deemed to have been created as a result of such misrepresentation should be invalidated. If someone other than HMRC had tried to resile for whatever reason from the statements made by Officer McKay, Mr. Tinkler, we say, would have been entitled to rely on estoppel by representation, because BDO acted on that representation to Mr. Tinkler's detriment, having no reason to disbelieve what was said to them. Now, that detriment, contrary to the position adopted by my learned friend, included not taking steps to demand that his tax return be amended to take account of the deduction which had been omitted when the return was filed in January 2005, and BDO answering questions that they weren't obliged to answer. And I come swiftly onto this. If this case were the other way round, HMRC would no doubt be pleading that estoppel does not lie against the Crown. But what is very strange in this particular case is that BDO, having been misled by what Officer McKay said, into believing a state of affairs to be true, which was to the disadvantage of their client, we now find ourselves faced with the assertion that the commissioners can rely on their own officers' misdeeds. And the commissioners, we say, use euphemisms to hide their responsibility for what happened. They talk about Officer McKay initiating an assumption, but what he did, in fact, was to make a representation on which he intended BDO to rely, which representations were, as the Court of Appeal said, untrue. And there can be no doubt that that was what he did and that was what he intended to do. And he probably never gave another thought to the matter after that, not because he was comforted and confirmed by what BDO later said and did, but because he didn't care what BDO had to say. Now, the commissioners may say, well, we don't know whether he cared or not. Well, we don't, because they didn't call the officer to give evidence. But in my submission, if one reads the letter from Officer Mackay of the 1st of July, and in particular that first sentence, and then one reads the letter from BDO of 6th of July, which is at page 258, and asks whether Officer Mackay was waiting with bated breath for BDO to confirm he had indeed issued a valid and effective notice of inquiry under Section 9A, the answer is plainly not. He wasn't interested in what BDO had to say. He was merely telling them what he had done, which is why the copy was enclosed simply for BDO's information and nothing more. He already knew, he thought, what he had done, and that was to open an inquiry. I mean, of course, he was wrong about that, but neither he nor HMRC nor those representing HMRC ever admitted that was so until they lost the appeal in the Court of Appeal some 13 years later. And during the whole of that time, the commissioners didn't care, and there's no reason to assume that Officer Mackay cared, whether or not Mr. Tinkler's letter had reached him, because their position was that the letter sent to BDO was itself a notice of inquiry which satisfied Section 9A. And one can see that in paragraph 17 of the Council's skeleton argument before the first-tier tribunal, which is at page 356 of the bundle. And what he said was, first, Mr. Tinkler's appointed agent, BDO, clearly received a valid notice of inquiry, it having been sent to them under the cover of the letter dated 1st of July 2005. So that was their argument. We couldn't care whether Mr. Tinkler got his because it was sufficed if BDO got theirs. So that, we say, was the background to this alleged estoppel coming into existence. And so our primary argument is, therefore, that estoppel by convention should not be engaged in a case like this, where A, the party who seeks to rely on the alleged estoppel was in fact wholly instrumental in the other party, B, accepting the relevant assumption because A made an untrue representation to B, on which he intended B to rely and on which he did rely. And that was that Officer Mackay had opened a Section 9A inquiry into 2003 to 2004 return and had issued the requisite notice to Mr. Tinkler. And behind that, we say, lies the larger question of the purpose of estoppel by convention and the circumstances in which the estoppel should operate. And in our submission, estoppel by convention exists in order to hold parties to a mutually agreed understanding, which is intended to regulate their dealings or a transaction into which they intend to enter. And since the relevant assumption has formed the basis for their negotiations, it would seem unfair and unreasonable for one or other party to depart from that assumption simply because it was never formally incorporated into their deal. And one sees that, for example, in amalgamated investments, where the bank continued to lend funds to the borrower group and to rely on the security, which it was believed by both parties to cover the loans, which, had the parties realized the truth, would have enabled them to amend the security or to call the loans in. And my lord.
I just want to test the point you're making about the HMRC making an untrue representation to BDO on which they intended BDO to rely. Now, if all they'd said was, we have served a letter on the taxpayer and an inquiry is underway, that is one thing. They said what they said and they enclosed the letter in question. So what they were doing was purporting to vouch what they were saying. So I think it's perhaps not the whole picture to say that they intended the recipient of their letter to rely on what you say is the representation. I wonder if you've got a comment on that.
I missed your suggestion as to what the letter which was enclosed was intended to do, my lord.
Well, it was vouching. It was the notice that had been that the revenue presumably thought at the time they had given to the taxpayer.
Ah, well, as far as that is concerned, the only thing which enables one to decide at this stage that it was incorrect is the address at the top. And I will come on to this in due course, but the point is that under the Taxes Act, the expectation is that the commissioners will send such a notice either to a taxpayer's home address or to his employment address or to his business address.
Yes.
And we say that if you look at the facts of the case, BDO were never informed, and there's no evidence that BDO were ever informed as to what Mr. Tinkler's home address was. And there may be a very good reason for that, was that Mr. Tinkler was at the time undergoing marital difficulties and was moving from place to place and had various deals on the go. So he didn't have a permanent place of residence, but most stuff went back to Windawath, which was the matrimonial residence. If BDO were unaware of what his personal address was, but they receive a letter from the revenue addressed to an address which they are not aware of, but they also know that Mr. Tinkler is expecting documents to go to his business address, they may well understand from what has been said by the revenue, what ought to be said by that letter, that the revenue knows better than they do what Mr. Tinkler's personal address and private address was, and had sent it to the right place. There was nothing on the face of it which told BDO that that was untrue. And that's the difficulty with the vouching of the letter, because nothing in that information would have brought to BDO's attention the fact that it was incorrect.
Well, that may be something which was within the knowledge of BDO, but you were saying that the revenue, or Mr. Mackay, intended BDO to rely on the representation of what he said in his letter to BDO, but he would not know about the taxpayers' peregrinations, would he?
Well, he knew that if he looked at the TBS system, he knew that Haybridge Lane had been removed from the system, and had been removed from the system as a result of acts which had taken place earlier. The submission of the Form 64.8 by BDO, which was at the business address, the filing of the self-assessment return, which had the business address at the top of it, the subsequent correspondence at Station Road. All that was information that he knew. And what he also knew was that he had, for whatever reason, decided to change the address to a different address. And what was found by the first tier tribunal was that the revenue were at fault in doing that, and they failed to make proper inquiries, and that certainly that led to them not being able to treat Haybridge Lane as being the private address.
Thank you.
So I was about to draw your attention to amalgamated investments and where the bank had continued to lend funds. And another case where the relevant assumption formed the negotiations was the Vista Fjord case, where the representative for the owner and the owner's agent had thought that the charter they were securing was governed by the commission agreement that already existed between them, but which applied on proper understanding to turn out only to apply to ticket sales. So our starting point is therefore the need for a transaction or a course of dealings between the parties, which the assumption is intended to regulate. And we say that neither of those existed here. All that happened was that the commissioners announced to BDO that they had opened an inquiry into Mr. Tinkler's tax return. That, if it were true, gave them certain rights and powers, and it rendered Mr. Tinkler subject to certain disadvantages. But what it did not do and could not do was to trigger a transaction or a course of dealing in the sense required for estoppel by convention. If one starts with section 9A on page 633, that tells you that an officer may inquire into a return if he gives notice of his intention to do so to the person whose return it is within the time allowed. And having done that, he is empowered to inquire into the return, and that has certain consequences. And one of those consequences is that the commissioners have the right to amend the self-assessment return without any regard to what the taxpayer may want to do. And by serving the notice, the commissioners also obtain the right to call for documents for the purposes of the inquiry. That's section 19A, which I don't think is in the bundle. And the taxpayer is prevented from amending his return with immediate effect, which is section 9B, 9 capital B. Those are the consequences of the service of a notice. But it would be absurd, in my respectful submission, to describe any of that as a transaction or as a course of dealing. Both of the phrases used in the authorities to describe the relationship which is supposed to exist between the parties and which the agreed assumption is intended to regulate. And I support that by some short references from some of the authorities in the area. The first is the Indian endurance case. And a succinct explanation of the estoppel is given by Lord Steen at page 1223 of the bundle. And just at letter E, one sees it's settled law, or it is settled that an estoppel by convention may arise where parties to a transaction act on an assumed state of facts or law, the assumption being either shared by them both or made by one and acquiesced in the other. The effect of the estoppel is to preclude the party from denying the assumed facts or law if it would be unjust to allow him to go back on that. Then similarly in amalgamated investments, all three judges focused on the application of the estoppel by reference to a transaction. And if one goes to page 123 of the bundle, we've set them out for convenience in our written case. And one sees, first of all, Lord Denning at page 689C, who says, where the parties to a transaction proceed on the basis of an underlying assumption on which they have conducted the dealings between them. And then Lord Justice Evely at page 693E to F, who says that estoppel operates to prevent a party from denying a representation or an assumed statement of facts in relation to the transaction supported by the representation or assumed state of facts. The estoppel does not go beyond the transaction in which it arises. And then Lord Justice Brandon at 694 and 697, who says respectively, two questions must be formulated as follows. Secondly, if the plaintiffs did not so undertake, are they nevertheless stopped from denying they did so by reason of the basis on which the transactions were conducted? And then they say, he goes on to say, first, the relevant transactions were entered into by the plaintiff and the bank. Secondly, for the purpose of those transactions, both bank and plaintiffs assumed the truth of a certain state of affairs. And then finally, he says the transactions took place on the basis of that assumption, and their course was influenced by it, in the sense that if the assumption had not been made, the course of the transactions would without doubt have been different. So we say that, especially telling is the statement by Lord Justice Evely, the estoppel doesn't go beyond the transaction in which it arises, but also the passage statement by Lord Justice Brandon that the relevant assumption has to be one on the basis of which the transactions related conducted. And then in Keenan Holland, Lord Justice Oliver giving my lady.
Yes, this point that's made at the end of Lord Justice Brandon's comment about the convention not going beyond the transaction. I mean, being the subject of a tax inquiry may have other repercussions for someone. For example, if they're applying to be a director of a company, or various jobs that you have to say whether you've ever been the subject of an inquiry by HMRC. So if there is an estoppel here, does that mean that, or does that, whether there is or isn't, does that affect the answer that Mr. Tinkler can give to that question? I mean, if there's no inquiry, has he ever been the subject of a?
Well, it depends what you mean by a revenue inquiry, because one of the points that one has to bear in mind here is that revenue inquiries take two forms. There are informal inquiries where the revenue simply asks questions about your tax return, and there are formal inquiries under Section 9A of the Act. And one assumes that the question which would be asked is whether or not Section 9A of the Act had ever engaged in relation to Mr. Tinkler. Whether he would be stopped from denying that because he was stopped from denying it vis-a-vis HMRC, if that were to turn out to be the case, would be a different question, I think. And I think one would have to say that it would be clear in those circumstances, you would have to ask, what was the question directed to? And if the question was directed to whether or not the revenue had ever been looking at Mr. Tinkler's tax affairs, then that would be one matter. But if the question were whether or not, in fact, a formal inquiry had ever properly been opened by HMRC, then clearly he could not, and I would certainly be arguing on his behalf if that were the case, he couldn't be stopped from denying that the case as far as the other party was concerned. But that's not to say that third parties are never able to take advantage of assumptions made between parties. Certainly there are arguments in some of the cases that perhaps that's possible. Though I'm not aware of any case which has actually turned on a third party being able to rely on an estoppel between A and B. My lord, Lord Briggs.
Oh, I think Lord Burroughs got there before me.
Okay, if you're happy for me to proceed. The question I've got, Mr. Thomas, is the proposition you're putting forward would seem to narrow the range of estoppel by convention in quite a fundamental way. Are you therefore saying that, for example, the principles set out by Lord Briggs, as he now is, in bench dollar, confirmed in Brindley Heath and so on, which do not appear on their face to have this transactional restriction, is an incomplete statement? Or are you not saying that?
Well, I'm not sure in either case it has the severity of effect that it has here. In Brindley Heath, the transactional nature of what was going on there was an application for the transmission of shares made to the board of directors of the company. And the board of directors of the company were obviously regulating their relationship with the shareholders on an ongoing basis. And so one runs into this question that arises in the Vista Fiat case, where does it matter that that relationship already exists, or is it sufficient that that relationship is going to continue to the future? and we ought to be thinking about how we deal with that in the future. For some of these cases are cases where one has historically run into contractual issues as well as whether or not there is in fact consideration if the contract actually makes proper provision for the way in which the parties should behave. As far as cases like bench dollar are concerned, there was a course of dealing, or there were dealings between the parties in my respectful submission, because what was going on there was the parties had reached a stage where the revenue were about to issue proceedings in the county court to recover national insurance contributions unless they managed to settle the matter with the taxpayers' representatives at an earlier time. So the question there were dealings between the revenue and the taxpayers' representatives is how you cut the deal and what you should do in those circumstances. Do we need to go off immediately? My lord.
So what's the principal distinction between a course of dealing consisting of communications between parties with a view to settling a piece of prospective litigation and a course of dealing consisting of an inquiry into a taxpayer's return conducted on the basis that it's a formal one, as a result of which, therefore, on its closure, the revenue can amend the return, amend the assessment?
I think it's mutuality of expectation of benefit. Perhaps that's the best way of putting it, that when you're dealing with trying to settle litigation, each party is looking for the benefit that they can get out of resolving the matter in the cheapest possible way and at the least possible stress. In the case of a Section 9A inquiry, one never reaches that stage. All one is concerned with is detriment to the taxpayer. Taxpayer has no interest or advantage in knowing that the revenue are inquiring into his affairs. It's an entirely different position from the position where somebody is about to sue you and you're trying to cut a deal with them as to the way in which that should be resolved or the process by which that should be achieved.
But does that not involve interpreting dealings as cutting a deal? And I would suggest that is a very restrictive view of what a dealing may be.
Well, no, it's
sorry, wait a minute, please.
Yeah.
The revenue has to deal with taxpayers, the taxpayer's return. Taxpayer submits a self-assessment saying, this is my position. The revenue looks at it and either accepts it, or if it has reason to make inquiries, it makes those inquiries. On what principled basis is that not a dealing while the bench dollar circumstance is?
Simply that the taxpayer has no control over the process at all. He's simply a passive party to the revenue's investigations, who's obliged to do things to his detriment, such as spend money on lawyers and accountants. It's not a case such as one is dealing with in bench dollar, where everybody is looking for a resolution. Of course, that's not the only kind of mutual dealings, and another kind of mutual dealings, which, for example, was mentioned by the court in the Grunt case was bailment. That was the mutual dealings that they had in mind there, where contractual or other mutual dealings such as bailment said the court. So one is looking for a mutuality, and that is why, in my respectful submission, the whole issue is one of mutuality. That each party is looking to achieve some benefit out of adopting the assumption in question. Well, there was no benefit to Mr. Tinkler in adopting the assumption that the revenue had opened an inquiry into his return. That was all.
But the BDO were dealing with the revenue at the same time, trying to put in a claim that in the tax year to 2004, he was entitled to a substantial tax repayment. The fact is, the taxpayer was discussing with the revenue what was the statutory obligation on the taxpayer to pay a certain level of tax. I mean, do any of the cases to which you refer us give any support for the idea that there must be mutual benefit in the relationship between the parties before estoppel by convention can apply.
I will come back, if I may, to you on that particular point at a later stage.
Thank you.
But in my respectful submission, the immediate answer is that in every single one of the cases that one looks at, there is a mutuality of expectation.
That, of course, is a different point, but yes, thank you.
Yes. And similarly, I refer to Keenan Holland, which was page 1056, where again, one was dealing with the question of whether or not, in fact, one had a conventional basis upon which the parties had regulated their subsequent dealings. That's 1056F. So I say that there is a need for the parties to intend to regulate their dealings between them on the basis of the agreed assumption. I do say, and I will come back on this, that one is looking for something which is potentially of mutual advantage to both parties. Something on which is of sufficient importance to them that they're willing to enter into it by reference to or on the basis of the relevant assumption. And we say that just didn't exist here. So my next submission is whether or not the estoppel by convention should apply to section 9A at all, and whether section 9A is the kind of statutory provision which ought to be subject to the estoppel. And the context of that is that a taxpayer cannot assert an estoppel against a public body, such as the commissioners. That's established by Lord Hoffman in Repretech, which is at page 1272, with whom the other members of the House agreed. And at paragraphs 32 and 33, he dismissed an argument by the claimant that the local authority was bound by estoppel by convention, because he said that was a private law concept which bound the conscience of individuals and ought not to be extended into the realm of public law, which binds everyone. And it was a case of planning control, but the principle, I say, is equally applicable to the public law of taxation. It was suggested by my learned friend this morning that it doesn't really matter, because Lord Hoffman then goes on at page 1, at paragraph 34 on the next page, to say, well, you've got the public law concept of legitimate expectation, which satisfies the taxpayer in these cases, or the planning applicant in that particular case. But he says, but it is no more than an analogy, because remedies against public authorities have to take account the interest of the general public, which the authority exists to promote. It can also take into account the hierarchy of individual rights under the Human Rights Act, whilst ordinary property rights are in general far more limited by considerations of public interest. So he's not saying that it's perfectly okay for a public authority to rely on estoppel by convention against an individual in circumstances where an individual cannot rely on it against the public authority. What one does, in my respectful submission, ask is, surely there ought to be mutuality in those circumstances, and that one shouldn't have an assumption which redounds to the benefit of one party but not the other. And public law rights are so clearly circumscribed that there can be no expectation that they will have the same benefit to a taxpayer as the revenue would get from being able to rely on estoppel in circumstances like this. And if one accepts that estoppel by convention is an equitable remedy, it would be odd, we say, in the extreme, if the commissioners were able to apply it against a taxpayer who was himself unable to apply it against the commissioners. Why should estoppel by convention apply intransitively? Why should it apply to section 9A? And the upper tribunal denied the application of estoppel by convention in the case of section 9A on the additional ground that the section was designed to protect taxpayers, and deciding that the reasons given by Lord Justice Oliver in Keenan Holland were equally applicable to the time limits in section 9A. that it was simply not open to the commissioners to extend time by agreement, and it was therefore equally improper for the commissioners to seek to rely on estoppel to achieve that which they could not achieve by agreement. And that's paragraphs 57 and 58 of the upper tribunal decision on pages 176 to 177 of the bundle. I don't need to take you to them at the moment. Now, there are instances in the Taxes Management Act which confer on the commissioners a discretion to relax strict time limits imposed on taxpayers. And 31(1)(b), which is at page 639 of the bundle, is the starting position. That's the section which allows an appeal to be brought against a closure notice. And section 31A on page 641 then specifies the time limit within which the taxpayer may appeal. 31A 1B. And then section 49, which is on page 643, deals with proceedings out of time. And it says an appeal may be brought out of time if on an application for the purpose an inspector of the board is satisfied there was a reasonable excuse for not bringing the appeal and consents in writing. And then there's a process whereby the commissioners can determine that in the event that the inspector does not. And by commissioners, it means the first year tribunal these days. But there's no such similar provision in relation to section 9A. And once one appreciates that that's how the 1970 Act provides for the closure of an inquiry, it's a small step to assume that a corresponding approach ought to be required on the opening of an inquiry, but section 9A is silent on the matter and only permits the commissioners to open an inquiry within the time allowed. And if one goes to a case called Raftopoulou, which my Lady Arden was involved in, I think, which is at page 1171, one sees the decision of Lord Justice David Richards. At page 1186. And at paragraph 70, what Lord Justice Richards says is this: Parliament has set down in the self-assessment system carefully designed time limits for inquiries, assessments and claims, which balance the need to give finality and certainty to taxpayers and the Exchequer with the need to provide sufficient flexibility to ensure fairness in the system. It has created a specific statutory procedure for the extension of certain of those time limits where it is considered it appropriate. And the upper tribunal's construction cuts across this balance without a clear warrant for doing so in the section. And that was a case where the taxpayer was trying to argue for an extension to the statutory time limits under the Taxes Management Act. And one can see that what Lord Justice David Richards in the Court of Appeal was saying was, well, if there isn't an extension made available by the section which provides for inquiries to be opened, you shouldn't be allowed to tinker with it by agreement between the parties. And in our submission, section 9A lays down the requirements to be met if an inquiry is to be opened. And it would be inappropriate for the commissioners to be able to persuade a taxpayer to abandon the statutory protection. And what the commissioners are seeking to do here by invoking estoppel likewise cuts straight across that careful balance described by Lord Justice Richards. And for that reason too, we say the attempt should be denied.
Sorry, just before you leave, so can I just clarify? So are you saying that it's not actually possible for the parties to agree between themselves?
To extend the time limit? Yes.
Well, but to serve the notice on BDO?
Notice on, I'm sorry.
On the agent, BDO.
On the agent. Oh, well, what I said before the Court of Appeal was that I hazarded that there might be circumstances in which perhaps the parties could agree, but I hadn't pinned them down. But if they did, they couldn't follow further than the position that was adopted by Lady Smith in the Spring Salmon case, where there had been an express agreement between the parties, not to extend time, but to serve the notice on the agent. And if one thinks about the decision in Spring Salmon, which is at page 1256 of the bundle, there was a question there whether or not the notice had to be in writing at all. And the reason of the judge, Lady Smith, isn't entirely easy to follow, but in my submission, it appears to be predicated on the basis that Section 9A is a relatively unimportant provision, which can, and the notice under the section, the Section 9A notice is a relatively unimportant document, which can therefore be served in a number of different ways, including service otherwise in writing. And that's what one finds at paragraphs 18 to 23 on page 1256. There was a very technical argument in that case, which my Lord Hodge may recollect, where the judge discusses whether or not the Taxes Management Act was one of the tax acts, because if it were one of the tax acts, section 828 of the Income and Corporation Taxes Act 1988, as it then would apply, and section 828832 would then require the notice indirectly to be in writing again. And what I would say about that is that since the decision of the Court of case, the upper tribunal in Inverclyde, which you'll find at page 817J, has refused to follow Spring Salmon at the urging of the commissioners, deciding that the Tax and Management Act is indeed one of the tax acts, as a result of which a taxpayer's notice has to be in writing. And all that gets one to is, well, there has therefore to be a rather greater degree of formality about the way in which Section 9A operates and Section 9A notices are served than Lady Smith thought. So that her decision that you could in fact agree between a taxpayer and the commissioners that you could serve the agent, perhaps is also likewise to be considered doubtful, having regard to the shift away from the informality and the move towards the requirements for the set out in Section 9A to be strictly adhered to, as indicated by the Court of Appeal and Raftopoulou. So no, I probably say these days, no, I don't agree that you could in fact serve the agent by agreement either. It's got to be served on the taxpayer in accordance with the terms of the section. Which brings me to the...
Mr. Thomas,
my lord.
You're not saying, are you, that this case is really about an extension of time? I mean, what is alleged to have happened here is that an estoppel by convention, well within the requisite 1-year period of notification, came into existence as a result of an exchange of correspondence between the revenue and the taxpayer's agent. Which I suppose, if one has to sort of categorize it in some ways, not that there will be more time to notify the taxpayer, but that whatever has happened up to now, be it good, bad, or indifferent, will be treated as a sufficiently valid launching of the inquiry within time.
Well, that is if in fact you get that far. We say that what has happened here is that at no stage did the revenue ever get around to serving their notice. So they're clearly out of time in accordance with the requirements of the section.
No,
And if they're out,
I'm talking about the nature of the convention, but bearing in mind that your submission is that what you can't do by agreement, you can't do by convention.
Yeah.
So
yes.
if what was done by convention, if it was a convention, was to treat the inquiry as having been validly opened and notified within the requisite year, the question then is, not, I think, whether Section 9A contemplates the revenue being able to extend time by agreement with the taxpayer, but whether it contemplates the revenue being able to agree with the taxpayer within time that the inquiry has been opened.
But as far as that is concerned, we too say that that too is improper as well, because you've got the very strict conditions laid down by Section 9A. And just as Raftopoulou goes to time, so it goes to the manner of service as well. Which brings me back to my Lord Briggs' decision in bench dollar, and the first of the ingredients of the estoppel, which is, of course, that the expression has got to cross the line. This is at page 1243 of the bundle. It's not enough the common estoppel assumption upon which the estoppel is based is merely understood by the parties in the same way. It's got to be expressly shared between them. The expression must have crossed the line sufficient to manifest an assent to the assumption, that being the Blindley-Heath edition. And as my Lord Briggs has said, the Commissioner's starting position is to say there was a common assumption that there was a valid inquiry on foot. And that's said to be a common assumption between BDO and HMRC. And the way in which the first-tier tribunal appeared to arrive at that is at paragraph 147 of its decision on page 210. And what they said, what Judge Mosedale said there, 210. Yeah. Ah, there we are. She found the shared assumption was a valid inquiry was communicated between HMRC and BDO for three reasons. First, the inquiry was acknowledged. Secondly, it was mentioned in an exchange of phone calls. And thirdly, BDO replied to the inquiries in their letter of November 2005. That is it. That is what is supposed to be the basis on which the assumption has crossed the line. And we say it's not enough that BDO may have thought that HMRC had opened an inquiry, nor does it suffice that the accountants were misled into believing that an inquiry existed. We say the appropriate response requires an assent to the proposition, an agreement or acknowledgement in some form that, having considered the matter, the assenter has concluded that's the right analysis of the situation. And this is the way it was put by Lord Justice Hamblin on page 160 at paragraph 165 of his judgment. But BDO at no stage endorsed, affirmed, or addressed the truth or accuracy of the statement made to them. The validity of the inquiry was not a matter that was ever referred to or considered in the communications between the parties. And in the upper tribunal at page 179, in paragraph 65, one sees that, in our view, halfway down at little c, there's nothing in the findings that show there was very clear conduct crossing the line by Mr. Tinkler, or BDO was intended to lead HMRC to assume the inquiry had validly been opened. The nearest it came was when it concluded BDO did not amend Mr. Tinkler's return because they believed there was an open inquiry, and HMRC did not seek to reissue the inquiry letter because they believed it had been validly opened. In our view, they said, and in my respectful submission, rightly so, those facts cannot be described as a communication of a shared assumption that the inquiry had validly been opened by very clear conduct. They were not mutually agreed positions. And what we say is all that happened that BDO accepted what had been said to them, which was that an officer had opened an inquiry. Nothing they said addressed the validity of that inquiry. HMRC, in fact, admit that in paragraph 55.3 of their, I think, 55.3 of their written case, where they say it is true that BDO did not refer in terms in their response to the validity of the inquiry, but they said it was necessarily implicit in the statements in their response to the inquiry was considered to be valid. I don't think, in my respectful submission, that anything that BDO did ever said that they had considered the matter and considered it to be valid.
But why then did they go on and answer the questions? If it wasn't valid, no point.
It wasn't a question of considering whether or not the conditions of Section 9A had been satisfied, which is what one would require for the inquiry to be valid. They'd been told by the officer what he had done, and on the face of it, without knowing more as to what the officer had done in changing the address and so on, that which appeared to them on the face of the record seemed to be in accordance with Section 9A, but it simply wasn't.
But they didn't make the inquiries, is the inference, isn't it?
They didn't know their inquiries had to be made.
Well, either way, they didn't make them.
They certainly didn't make them,
No.
but they had very good reasons for not doing so. Had they
But
been
they would have
told,
been aware there was no point in answering the inquiries made by the revenue unless it was a valid notice. So obviously,
well, it is a prudent thing to do on the part of a taxpayer to answer questions that are asked of you by an inspector of taxes, by an officer of the commissioners, whether or not they have opened a Section 9A inquiry.
well, no, you may not. Your position may be prejudiced by the answer, so you may not want to, it may not be automatically in your interest to answer the inquiry. It might be better to think whether this is an inquiry you have to answer.
If one actually looked at the nature of the inquiries that were being made of BDO in this particular case, they were very simple inquiries relating to the ownership of the Ukrainian properties. There was nothing difficult about it. They weren't being asked to do anything which could possibly have prejudiced the inquiries.
Absolutely. I'm not intending in any way to discourage taxpayers from answering inquiries, of course not. But there does come a point, doesn't there, when one has to say, if you're going to take a point about the validity of the notice which initiates the inquiry, you have to take that pretty early on.
Well, if the party who has not told you the whole of the truth carries on not telling you the whole of the truth, and the whole of the truth included, by the way, I changed the address on the system and sent this to an address that you hadn't asked me to send it to, then in those circumstances, once you know that, yes, in those circumstances, you should be putting your hand up and saying there is something wrong here. But that never appeared on the face of the record as far as BDO were concerned, and I'll come on to explain that when I get to the correspondence between the parties in due course.
While you're still on this theme, you're saying that what had to cross the line was something that could be construed by the revenue as a statement by BDO. We have considered the matter and we agree with you that the inquiry is valid.
Yeah.
Yes. Now, does that tally with what Lord Hamlin said at paragraph 53 of his judgment, which is, bear with me, at page 158, where he quotes from Chitty on contracts? And what Chitty is doing is lifting from the Republic of India case the passage which you read to us, where it says that estoppel by convention may arise where both parties to a transaction act on an assumed state of facts or law, the assumption being either shared by both or made by one and acquiesced in by the other.
It depends.
Now, acquiescence really is the manifestation of consent either by silence or by conduct. You would say it would have to be conduct across the line.
Yeah.
But it is not. It doesn't go anything like as far as to say we have considered this matter and we agree with you. That would be a shared. That would be a shared assumption. All that's required, according to the House of Lords in the Republic of India, is an assumption made by A and acquiesced in by B.
It comes down to, my lord, what exactly constitutes acquiescence for this purpose. And I say that it's got to go further than simply accepting what is told you because you don't know any better, and because the manner in which it's been addressed to you leaves you in a position where you don't know the full truth, which would enable you to make your mind up properly. You haven't really acquiesced if you're labouring under a misapprehension which arises as a result of the failure of the other party to give you the full picture.
But I was going to say that convention estoppel is not about the assumption being the truth of the assumption. It's about the fact of the assumption. You may have a common assumption as to something which doesn't accord with the facts.
Oh, you can in certain circumstances, as long as you both agree to adopt that as the way in which you are pressing forward. But simply, that is not this case.
You don't have to animadvert to the correctness or otherwise of the assumption.
Well, it's in my respectful submission, what one has to do is simply do rather more than simply say, you've told us that there's an inquiry on board, and in those circumstances, that being the case, we are going to do this and that. That's not acquiescing in the assumption. That's simply being the subject of a representation.
But that may not be all, because when you make such a statement to a professional advisor, you have to assume, do you not, the professional advisor will take instructions and report back to his own client.
If in certain circumstances one would, but in this particular case, there was no need to do that, because the way in which the letter was framed was not framed as being sent to BDO on behalf of Mr. Tinkler. It was framed in circumstances of this being information provided for the benefit of BDO alone. That's the 1st of July letter.
But it wouldn't be at the minimum. Are you happy, Mr. Tinkler, for us to carry on and answer the inquiries?
There are, if one looks at what is happened here, and if I might come back to that later, because I'm running out of course, I think, otherwise on that. So the second criteria is assumption of responsibility. And this takes us back to page 1243, 1244 by now, I think, the bundle. The expression of the common assumption by the party alleged to be a stop must be such that he may properly be said to have assumed some element of responsibility for it, in the sense of conveying to the other party an understanding that he expected the other party to rely on. And we simply say, well, there is no evidence whatsoever that BDO expected or intended or wanted HMRC to rely on the alleged understanding that there was indeed a valid inquiry on foot. Nothing that was said in any of the correspondence between the parties could possibly have conveyed to HMRC an understanding that BDO expected or intended HMRC to rely on BDO's understanding. And neither BDO nor their client had any interest in conveying such an understanding. An inquiry is disastrous for a taxpayer. It will cost a considerable amount of time, money, and distress. The bills incurred in engaging somebody to deal with the inquiry and the delays in recovering monies are clear reasons why Mr. Tinkler and his representative would have had absolutely no interest in conveying.
Just a short factual question. In the letter of engagement between BDO and Mr. Tinkler, it said, this does not cover our dealing with an inquiry on your behalf. If there's an inquiry, we'll have to enter into a new agreement or an additional agreement about fees for dealing with that. Do we know what happened as regards that?
If you go to page 361 of the bundle, there's a letter from Mr. Jones, which was written to Mr. Tinkler very shortly before the hearing. And the problem that we had in the hearing was that Mr. Jones's wife was very seriously ill and he couldn't attend. So he wrote a letter to explain the background to what was going on. And one sees that what in the third paragraph down, the answer, I think, to the question my Lady Rose is asking. They didn't think of it as involving much work. My lord.
Might it be said that that part of BDO's July reply, which said, look, client's got a £2 million loss arising out of the gilt strip, which if there were not a valid inquiry, we could deal with by amending the return. But nonetheless, since there is an inquiry, would you mind dealing with it, as it were, within the inquiry and making an allowance for that amount? Might that not be said to carry with it an invitation to the revenue to rely upon Mr. Tinkler, that's BDO's principal's subscription to the common understanding that there was a valid inquiry?
My lord,
I'm slightly amending the that paragraph in bench dollar in the way I gently put to Mr. Gammy this morning. It's not that they thought the revenue would, or didn't think that the revenue would rely on their own understanding, or the fact that there was, or the assumption that there was a valid inquiry. It's they would rely on their client's subscription to that common understanding, signing up to it, i.e. that it's common, not just an understanding in fact.
in my respectful submission, all that one gets from that passage about we're not allowed to have our money back now is its narrative. It's describing the detriment which is being suffered by Mr. Tinkler and asking whether or not in those circumstances the revenue would do the decent thing, which they didn't do. It wasn't actually technically correct to say that they couldn't have amended the tax liability at that time due to the open inquiry. As I understand the relevant section, they could have amended it, but they don't have to. But what happens is by opening an inquiry, you put the taxpayer under a disadvantage whereby he can no longer himself thereafter amend his tax return. And if he's left something out, then he's stuck with that until the inquiry closes. And one can see how long the inquiry took to close in this particular case, over 7 years. And of course, this was something that BDO had left out of the tax return. So there may well have been very good reasons why they weren't that enthusiastic to bring that to Mr. Tinkler's attention. They should have included it in the tax return, but they didn't.
Thank you. Thank you.
And the representation point we say, and this assumption of responsibility is obviously the starting point we say that is Lockymel, or I'll start with what my learned friend calls the August Leonhardt case, which is at page 1038, and we can pick it up at 1044, which is the passage that you've already seen. And we just say we rely on that too. And what that requires, this is in the second column on page 1044, is some statement or conduct by the party alleged to be stopped on which the alleged representee was entitled to rely and did rely. So one's got to have that reliance in the one sense, and you've got to have a manifest representation crossing the line between representor and representee, either by statement or conduct. And that ought to be clear and unequivocal. That's what's required in order, we say, to be something which crosses the line. Not merely stating something or accepting something, but doing it in a way such as to engender an understanding on the party on which the other party is entitled to rely and did rely. And then one sees that in support of that submission, that analysis, Lord Justice Carr relies on Mr. Justice Dixon in the Grunt case. And one sees that it's got to be a mutual mistake and mutually manifest. And as I say, if one goes to the Grunt case, which is at page, and starting at page 1344, I apologize. In the judgment of Chief Justice Latham, one sees at the very top a reference to a decision of Lord Justice Scrutton in Verschure Creameries and Hull and Netherlands Steamship Company, that the relevant principle is that a person cannot say at the one time that a transaction is valid and thereby obtain some advantage, to which he would only be entitled on the footing it's valid, and then turn around and say it's void for the purpose of securing some other advantage, that is to approbate and reprobate the transaction. So maybe that's the mutually beneficial conduct point. And then further down, one sees in the judgment of Mr. Justice Dixon at page 1351, in the second paragraph, the principle upon which estoppel impeys, which of course is the historic antecedent to estoppel by convention, is founded, is that the law should not permit an unjust departure by a party from an assumption of fact which he has caused another party to adopt or accept for the purpose of their legal relations. So you've got to have a cause, and it's got to be for the purpose of the legal relations. And then at the foot of the next page, 1352, and just below the last break, the justice of an estoppel is not established by the fact in itself that a state of affairs has been assumed as the basis of action or inaction on, or that a departure from the assumption would turn the action or inaction into a detrimental change of position. It depends also on the manner in which the assumption has been occasioned or induced. Before anyone can be estopped, he must have played such a part in the adoption of the assumption that it would be unfair or unjust if he were left free to ignore it. So it's not merely saying, yes, I agree with what you say. You've got to have played a positive, proactive role in the creation of the shared assumption. And then Overleaf, he gives a number of examples from Thompson and Palmer, which he delivered the judgment in, which gives a convenient summary of the sorts of cases where you would be so found to have been estopped. Whether a departure by a party from an assumption should be considered unjust and immiscible depends on the part taken in occasioning its adoption by the other party. He may be required to abide by the assumption because it formed the conventional basis upon which the parties entered into contractual or mutual relations, such as bailment. So there again, there's the mutuality issue arising. Or because he has exercised against the other party rights which would exist only if the assumption were correct. Or because knowing the mistake the other laboured under, he refrained from correcting him when it was his duty to do so. So it's not enough that he knows the other side's correct, he's got to have an absolute duty to correct him. or because his imprudence, where care was required of him, was the proximate cause of the other party adopting and acting on the faith of the assumption, or because he directly made representations upon which the other party founded the assumption. Well, if you look at those and you ask, were they all applicable to Officer Mackay? The answer is yes, pretty much all of them. And if you ask whether any of them was satisfied by BDO, in my submission, the answer is no.
Could I take you back to the start of the quotation from Thompson and Palmer? The second sentence, he may be required to abide by the assumption because it formed the conventional basis on which the parties entered into contractual or other mutual relations such as bailment. Now that you can fairly say is a mutuality point. But the next phrase strongly suggests that a transactional mutuality isn't needed. Because it says, or because he has exercised against the other party rights which would exist only if the assumption was correct. He then refers to certain cases, which I haven't obviously had time to look at yet. But it does, that passage. I mean,
you're back to Vesha. You're back to Vesha creameries again, and what Lord Justice Scotland said, but those are rights which were being exercised by Officer Mackay. They weren't rights which were being exercised by BDO or Mr. Tinkler in this case. Neither of them had any such rights.
Thank you.
Can I just ask you, Mr. Thomas, these extracts from the Grant case, is it absolutely clear that Justice Dixon was talking about estoppel by convention here, rather than linking in other types of estoppel?
I think this is generally understood to be estoppel in pays or estoppel by convention, as it in the modern form is. It was looking at something which was effectively estoppel by convention, although it wasn't called that at that time. It's not dealing with other representational estoppels in the same way.
No. Thank you.
I mean, if one goes back to page 674, unjust departure by a party from assumption of fact which he's caused another party to adopt or accept for the purpose of their legal relations. That's on page 1351. That, we say, is looking at estoppel by convention, really. And ever since these passages have, of course, been adopted by the later United Kingdom courts as the foundation upon which they built estoppel by convention.
But just, if I may just chip in, just going back to the point you made at the beginning about the need to have a clear boundary between negligent misrepresentation and this kind of misrepresentation. Is what you're saying that if you allow mere sort of acquiescence or acceptance without this additional step, then you run the risk that whenever there's been a negligent misrepresentation by one party to the other in a contractual context, the representor says, oh well, but you had the information available to you to check whether it was right. You didn't check. We all then carried on as if that were true, and now you're stopped from denying that it's true.
Yeah,
that's the risk of
the
boundary.
It is. I told you something, you foolishly agreed with me or accepted it as true without more. You've signed up to it, and estoppel by convention in the wider form that the revenue want to chip away into, then allows you to do that and rely on something which is wholly inappropriate and inequitable that one should be bound by. So we say that you've got to be conveying an understanding you expect the other party to rely on, and it does go much further than the commissioners would have you agree. And my learned friends rely then on what Lord Denning said in Amalgamated Investments. And they said that the right approach is what Lord Denning has to say. And they say that what Lord Denning said in Amalgamated Investments has been endorsed on many occasions. And I thought that to correct the record, I should also point out that it has been subject of considerable judicial criticism. And I start with what Lord Gough himself had to say about that very passage in Johnson and Gore Wood, which is at tab 10 of the authorities bundle, which we can start at page 938 very quickly and move through it. And by way of background, it involved an action in negligence against a firm of solicitors, Gore Wood. There had originally been an action brought by Mr. Johnson's company against the solicitors, and that had been compromised in the 6th week of the trial. The solicitors had at that time notice of Mr. Johnson's separate claim, and provision was made in the settlement agreement for limiting that part of that claim as part of the compromise. And then at a later stage, Mr. Johnson issued his own proceedings, and very late in the day, Gore Wood sought to strike out his claim on the basis of abusive process. And Mr. Johnson, in turn, said, well, no, you are stopped from seeking to strike out on that basis. And Lord Bingham starts at page 938 with abusive process, which he deals with. And then he deals with that from 938 to 947. And then at 947, he starts to deal with estoppel by convention. And he deals with that all the way through to 950. And at page 949, little d, one sees the relevant passage. Neither party challenged the correctness in principle of Lord Denning's statement in Amalgamated Investment, which I quote. And he then quotes the doctrine of estoppel, one of the most flexible and useful in the armory of the law, overloaded with cases, at the same time as being sought to limit it by a series of maxims. All these can now be seen to merge into one general principle, shorn of all limitations. When the parties proceed on the basis of an underlying assumption, whether of fact or law, whether due to misrepresentation or mistake makes no difference, on which they have conducted the dealings between them, neither of them will be allowed to go back on that assumption where it would be unfair or unjust to allow him to do so. If one of them does seek to go back on it, the courts will give the other such remedy as the equity of the case demands. So it wasn't a case where that passage was ever challenged by the parties. And at page 949 G to H, he decides, first of all, that Gore Wood, 949D, I think he decides that they were stopped. 949 G to H, he decides they're stopped. And then at 950 C, he says, if contrary to that, they were not stopped, nevertheless, it would still not have been abuse of process for Mr. Johnson to bring the proceedings. Now, at 954, Lord Bingham Lord Gough joins in, and Lord Gough, first of all, deals with Lord Bingham's statements, and one sees that what Lord Gough does is to agree with the abusive process. On the question whether there was an abusive process on the part of the plaintiff, my noble and learned Lord Bingham has reviewed the facts. I find myself in agreement with him, but that's only on abusive process. when one gets to estoppel, he again refers to the reliance placed on the relevant passage by Lord Denning in the amalgamated investment case. And halfway down 955, he describes that broad statement of law as characteristically bold. That's at 955E. He indicates that the passage has technical difficulties so far as estoppel by convention is concerned. Notes along the way at 955F that actually Lord Denning doesn't even mention estoppel by convention in what he says. And then points out by reference to a passage from Spencer, Bower and Turner at the bottom of that page and the top of the next page, that what Lord Denning was trying to do in that passage was to seek to undermine the doctrine of contractual consideration and to give contractual effect to assurances as to the future for which no consideration had been given. And he then went on to describe his own part in amalgamated investments. And one sees that at 956 B to C. And he says, cautiously, and I still think wisely, I founded my conclusion on a broader basis of unconscionability, not on estoppel by convention. And it was perhaps in pursuit of that jurisprudential goal of creating a single unified doctrine of estoppel that Lord Denning, in the relevant passage, appears to abandon the corresponding provision of or concept of responsibility. One will remember that he says, doesn't matter whether it's misrepresentation or mistake. It may be that what Lord Denning meant in that passage was misrepresentation by some third party, which affected both parties' minds. But I would respectfully submit that if it was intended to suggest that a party can be bound by an estoppel arising from a misrepresentation, an assumption which he has adopted as a result of the other party's misrepresentation, he was wrong to do so. And whilst in Johnson and Gore Wood, I would also point out that my learned friends suggest that the Lord Cook and Lord Hutton had agreed with Lord Bingham on his analysis of Lord Denning's passage. They referred and they say that Lord Cook and Lord Hutton expressed agreement on this aspect of the case. I have been through Johnson and Gore Wood, and I can find no place where either of those judges actually agree with what Lord Bingham said about estoppel by convention. One turns to page 958 very briefly. One sees what Lord Cook said, and what he says is, I have had the advantage of reading in draft the speech of my learned friend Lord Bingham. I agree with what all that he says on the subject of abuse of process and says nothing about estoppel at all. That's at 958 D to E. And at page 966, Lord Hutton does likewise. At the very foot of the page, I have had the advantage of reading in draft the speech of my learned friend Lord Bingham. I am in full agreement with his speech on the subject of abuse of process. And then Lord Millet, who's at 976, does deal with the rejection of the abuse of process first, but then goes on to turn the estoppel by convention on its head and says that even if this were not the case, I agree that it would be unconscionable for the firm to raise the issue after the way in which it handled the negotiations. And he resorts to unconscionability instead of estoppel by convention as far as that's concerned. And he says, I would not put it myself on the ground of estoppel by convention. So nobody in Johnson and Gore Wood on the face of it, other than Lord Bingham, actually endorses what Lord Denning has to say about the absence of absence of relevance of misrepresentation at any stage. Similarly, I don't need to take you to it because you've seen it already. the decision of the Court of Appeal in Keene and Holland. Again, there's a reference to Lord Denning's statements, and what the court says at page 1055 very quickly is 1055D to E. It should perhaps be added that Lord Denning was alone in expressing the proposition as broadly as this, and that at 1056G down to the very last break on that page, one sees the argument being put by counsel for the tax for the landlord based on what Lord Denning had said in Amalgamated Investments. And what the Court of Appeal says at the very foot of the page is, so broad a proposition cannot be deduced from the actual decision in the Amalgamated Investment case, and although it may be supported on the basis of a very wide proposition of the Master of the Rolls, it cannot, in our judgment, be right. And although they don't say whether it's the proposition or what Lord Denning says is right, in my respectful submission, the Court of Appeal was expressing its concerns about both in that passage. Picking up another complaint that was made by my learned friend in this area, in paragraph 55.4 on page 86 of the bundle. The paragraph, it suggested that the parties proceeded for almost a decade on the assumption that the inquiry had been validly opened and in due course closed. And they give three examples which they say demonstrate that. First, they say they actively engaged with the inquiry by responding to the questions raised in the course of the inquiry and apologized for the delay in doing so. I say that doesn't take them anywhere. Secondly, they say the Commission has sent a formal information notice under Section 19A addressed to Mr. Tinkler, a copy of which was sent to BDO, which could only have been done if an inquiry had been validly opened. Well, that's what HMRC did, it's not what BDO did. Thirdly, correspondence from BDO in 2009, they say referred to the ongoing revenue inquiry. That's a letter which one finds at page 282 of the bundle. And what this was a letter written by BDO in which they were seeking time to pay, for Mr. Tinkler to pay a very substantial tax bill of some £5 million, I think. And they then set out the circumstances in which they thought it might be appropriate for the commissioners to act generously. And on the second page, on page 283, halfway down, one sees tax payments and two schedules of payments made by Mr. Tinkler. And in the second paragraph, one sees the first schedule shows the tax and interest payable, taking into account a repayment due of some £635,000, relating to the 2003-2004 tax year. This has not been repaid to Mr. Tinkler due to an ongoing revenue inquiry. That is the totality of the correspondence between the parties after 2005 that the revenue are able to rely on. And again, I say that sentence is narrative, nothing more. The time for serving a notice of inquiry is many years elapsed. And it amounts to no more than this. Having had the wool pulled over their eyes by the officer in 2005, BDO had yet to be disabused of the officer's representation. And lastly, on page 87, the commissioners complain that when Mr. Tinkler appealed in 2013, he didn't immediately raise the issue of the invalidity of the notice of inquiry. And it was only in 2015, shortly before the hearing, that he amended his notice of appeal to argue that the inquiry was invalid. If I take you to page 295, one sees the notice of appeal, the original notice of appeal, and the grounds of appeal. And at the foot of the grounds of the appeal,
Thomas, I wonder if you can give me the page number again. I'm sorry.
295, my lord.
Thank you very much.
This is in the notice of appeal. And the very last paragraph of that, the taxpayer also reserves the right to challenge the refusal, probably, possibly by way of a preliminary point, on the ground that it resulted from an inquiry into his return not commenced within the time limits laid down by the Taxes Management Act, Section 9A. And this is the document is the one sees on 294, which was filed on the 24th of February 2013. So it's already there. And if one goes to page 584 in the bundle, in page 48 of the transcript, which is the bottom right-hand corner of that page, one sees questions asked of Mr. Tinkler. And the first is, do you recollect when you first saw a copy of the letter of the 1st of July 2005? And what he says is, I do recollect that. That was when we received information from BDO sometime around January 2015. And we were emailed information from their file, which was a copy letter that is on that page of 1st of July. So Mr. Tinkler never got to see that until 2 years after he filed his notice of appeal. So he did, in my respectful submission, remarkably well to put a placeholder down back in 2013 when the argument was first ventilated. And then going back to page 88 in the Commissioner's written case again, the Commissioner's other argument on assumption of responsibility is that one can disregard the misrepresentation which leads to the adoption of the common assumption, because the fact that the proposer has already adopted the assumption does not permit one to disregard the other party's later conduct, which they describe as participation in mutually manifest conduct demonstrating the relevant view. And in my respectful submission, there is absolutely no basis on which you can recharacterize BDO's conduct in that way. And I would invite you simply to follow the decision of the Court of Appeal and paragraph 65 of what Lord Justice Hamblin said on page 160 as being the correct description of what happened. They had no reason to doubt the truth and accuracy of what they were being told. They proceeded on the reasonable assumption that what they was told was true, but at no stage did they endorse, affirm, or address the truth or accuracy of that statement, and the validity of the inquiry was not a matter that was ever referred to or considered in the communications between the parties. And we say there's nothing in my learned friend's case which demonstrates or refers to evidence which demonstrates that BDO reinforced or perpetuated what Officer McKay had thought. And there are two reasons for that. First, because they never called any evidence below to demonstrate the truth of the allegation. And in particular, they never called the officer. And secondly, because it's plainly incorrect. And if one looks at the arguments that they advance on page 90 in paragraph 63, I say that 63.1 is a misconstruction of the letter of the 1st of July. Nothing in that letter showed that that reflected BDO's own understanding that there was now a valid inquiry on foot. And then in 63.2, they suggest that there's a flaw in the reasoning of the Court of Appeal on the basis that it's implied that a shared but unspoken or unconscious assumption on which the parties act would not be sufficient to found an estoppel. We say in those circumstances, the conduct of the other party has got to be clear, unambiguous, and intended to represent to the other party that he agrees with the assumption, wants the other party to rely on the understanding, and to undertake the transaction between them on the basis of the assumption, right or wrong, and none of that existed here. They rely on that by reference to Lord Steyn in the Indian Endurance case, which is at page 1223 of the bundle. Unfortunately, the citation is a little short on the full amount. And if one looks at what Lord Steyn said, yes, indeed, he does talk about the acquiescence. But then he goes on to discuss the manner in which the Court of Appeal decided the case below. And he says, it was argued by the plaintiffs that Lord Justice Staunton had held in the Court of Appeal that a concluded agreement was a requirement of an estoppel by convention. That argument was based on the observation by Lord Justice Staunton that it is essential that the assumption be agreed for there to be an estoppel. At first glance, that observation seems to bear out the argument entirely. But earlier, Lord Justice Staunton had referred to an agreement or something very close to it. In that context, I do not accept the Court of Appeal misdirected itself on this point. So what, in my respectful submission, Lord Steyn is saying is that you do need an agreement or something very close to an agreement in order to found the shared assumption for the purposes of an estoppel by convention. Again, you're back to my argument that the representation in words or conduct requires you to suggest that matters are to be understood in accordance with the relevant assumption and to indicate that the other party is expected to rely on that understanding, which takes us back to Locumal again and to Grunt. I do accept that if somebody takes a particular step, which is based on an incorrect assumption, and the other party stands by, and though in a position to disabuse the first of his error, and under a duty to do so, fails to do so and remains silent, then that comes very close to an agreement. Both parties are proceeding on the basis of the assumption. Blindley Heath is really that sort of case, given the position of the directors who had a duty to consider whether or not it was appropriate for them to issue shares to the applicant, and if one, or to register the transfer of shares. And if one goes to page 723, paragraph 92, one sees that Lord Justice Staunton's proposition in the Court of Appeal in the Indian Endurance is then expanded by the Court of Appeal in Blindley Heath to say it's got to sufficiently manifest an assent to the assumption in question. You can't simply keep quiet about it and thereby manifest an assumption. There's got to be more to it than that. And in paragraph 88, if one goes back to page 722, you've got to have an estoppel by convention demonstrating conduct crossing the line and unambiguously giving rise to a clear assumption of fact or law on the faith of which both parties unequivocally proceed. I'm about to start on another point, my lord, and I was wondering whether or not that was a convenient moment to close this afternoon's process.
Well, Mr. Thomas, if you're comfortable that you're running fully within time.
I should be fine.
Yes, then if you're moving on to a new point, I think we'll be content to stop at this stage. Thank you very much. We'll resume tomorrow at 10:30.